The travails of the 17th Chief Justice of Nigeria, Justice Walter Onnoghen, began on the 10th of January 2019 when the federal government filed a 6-count charge against him before the Code of Conduct Tribunal over allegations of false declaration of assets. Justice Onnoghen's charges are anchored on Section 15 of the Code of Conduct Bureau and Tribunal Act 1991. The Act makes it compulsory for all public officers immediately after assuming office and every 4 years thereafter to submit to the Code of Conduct Bureau a written declaration of all properties, assets and liabilities. According to the petition, the Chief Justice of Nigeria has been accused of failing to declare his assets immediately after assuming office as a Justice of the Supreme Court in 2005. He has also been accused of falsely declaring his assets prior to assuming his duties as the Chief Justice of Nigeria in 2017 by omitting 3 domiciliary accounts, pounds, dollars and euro accounts, and 1 naira account maintained with Standard Chartered Bank since 2011 in his Code of Conduct Bureau Asset Declaration form. Onnoghen, who reportedly filed CCB forms in 2014 and in 2016, failed to mention the existence of the accounts, which amounts to false asset declaration and is a breach of the CCB Act, which is a punishable offence by the law. If Justice Walter Onnoghen is found guilty according to Section 23 of the Code of Conduct Bureau and Tribunal Act, he will have to vacate office, be disqualified from holding public office for the next 10 years, and all assets connected to the charges forfeited to the government. However, according to the 3rd Schedule to the 1999 Constitution of Nigeria, the National Judicial Council, of which Onnoghen is the chairman, retains the power to appoint, dismiss, and exercise disciplinary action over the CJN. The historic trial of the number 1 citizen of Nigeria's judiciary before the Code of Conduct Tribunal was to begin on Monday, the 14th of January 2019. However, in an interesting development, while Onnoghen was noticeably absent at the CCT, his defense team, comprising 47 senior advocates of Nigeria and 43 other lawyers, led by Walter Onnoghen, argued that the Chief Justice had not been served the charges and summons for his tribunal appearance in person. On that ground, the hearing was adjourned to the 22nd of January 2019. In a subsequent development, however, the Federal High Court in Abuja, in a ruling delivered by Justice Evelyn Maha on 2 separate ex parte applications before the court, filed by 2 civil society organizations who joined the Attorney General of the Federation, the Chairman of the CCT, the CCB, the Inspector General of Police, and the Senate President as defendants in their respective suits, ordered all parties involved, including the CCT, to maintain the status quo and refrain from pursuing any action against Onnoghen until January 17, 2019, when all parties are to appear in court. An ex parte application, which simply refers to an application based on the argument of one party only, according to the Abuja High Court rules, can be dismissed by the court within 7 days after its service based on the application of its defendants, which means that the CCT has 7 days to fight this new development. The next few weeks are indeed crucial to the future of Walter Onnoghen, and all eyes are to be on the judiciary and the Code of Conduct Tribunal to ensure that justice is indeed served. Roots TV, Nigeria.